Thank you for coming to today's webinar, Safeguarding Your Business and Website from Privacy Act Risks. And it's presented by DE attorneys Michael Burke and Stacy Thompson. Michael is a partner and one of the co-leaders of our business litigation and alternative dispute resolution practice group. He's based in Boston. And Stacy is a senior associate of that same practice group that's based in Providence, Rhode Island. Both have been at the forefront of assisting businesses with these types of cases, these types of privacy claims being seen throughout the country. Some reminders before we get started. All attendees will be emailed a copy of the slide deck we're about to present. And also, there will be a recording of this webinar available to you via YouTube link that will go into that same email. Those assets will also be available via the Darrow Everett website via the Resources tab. Finally, if you'd like to ask a question of our panelists, you are more than welcome to by going to the bottom of your screen. The Q&A function on your screen is the place to ask those questions. Michael and Stacy will be answering those questions following their presentation. So if you do want to ask the question as you think of it while they are speaking, we will get to those at the end of the show. And we'll answer certainly as many as we can. Stacy, I know that you are up first. I'm going to share my screen so that you can get started. And certainly thank you both, Michael and Stacy, for being here.
Thanks, Roger. And good morning, everybody. Or I should say good afternoon for those on the East Coast. Good morning to those potentially on the West Coast and elsewhere throughout the country. My name is Stacy Thompson. I'm an attorney at Darrow Everett. As Roger stated, I've been practicing litigation for approximately 13 years. I'm licensed to practice in California, as well as Massachusetts and Rhode Island. And both Mike and I have been seeing a lot of these Privacy Act claims in the past several months, and we thought it would make sense to put a presentation together to address some of the commonalities we're seeing and inform business owners and those who run consumer-facing websites how best to protect yourself against these types of claims. Roger, if you could go to the next slide, please.
Absolutely. Sorry about that.
That's okay. Just a little bit of background. Most of the claims that we're seeing are being filed under the California Invasion of Privacy Act, which is also referred to as SIPA. But businesses all over the country are being targeted under various privacy acts, as well as the Federal Wiretap Act. And the spur in litigation has arisen as a result of an unpublished Ninth Circuit opinion, which the Ninth Circuit encompasses California, Arizona, Nevada, Oregon, Washington, Idaho, and Montana. And in June 9th of 2023, the Northern District of California, in an unpublished opinion, ruled that the Wiretap Act in both California and the Federal Wiretap Act applies to internet communications. And as a result, there have been a flood of these claims where attorneys are hooking on to this decision in order to attempt to get quick settlements from unsuspecting businesses. And so the primary basis that they're bringing these claims is a statutory penalty under SIPA, which requires a $5,000 per violation penalty. You don't have to prove any other damages. That's the way the statute is written. It has since been interpreted by the courts, which we will get to later. But as it stands, the statute requires a $5,000 per violation penalty, and firms are using that as a hook to try and get quick settlements. And in bringing claims for violations of SIPA, Like I said, they usually are alleging Federal Wiretap Act, which has an eavesdropping element. And a lot of the third-party software that is installed on consumer-facing websites have tracking elements that they are trying to allege people are aiding and abetting these third parties through wiretap activities or eavesdropping activities. Next slide, please, Roger. There are cases, for example, in Massachusetts, where a similar argument was made, but the courts have ruled that simply browsing on a website is not enough to establish a violation of the Wiretap Act. For example, in Kathleen Vita versus New England Baptist Hospital, which was a Massachusetts Supreme Court ruling that came out, I believe, in October of this year, that these types of activities, simply browsing a website, does not rise to the level of activity that would be considered a violation under the Wiretap Act. So while the courts in California have found that simple browsing can sometimes lead to these types of violations, Massachusetts has held that that's not the case. So it really depends on where you were located. But California is the primary driver of most of these claims at the moment. And next slide, please. And I'm going to pass it over to Mike.
Okay, good afternoon, everyone, or good morning for those in Western time zones. My name is Michael Burke. I'm a partner and co-chair of Darrow Everett's Business Litigation and Dispute Resolution Practice Group. I'm based in Boston. I've been working as a litigator here for about 12 years. But they focus on general business litigation, intellectual property litigation, such as trademark and copyright disputes, and now have developed the focus with Stacy in privacy litigation. And as Stacy mentioned, the vast majority of the claims we're seeing, whether or not your business is located in California, are being brought under SIPA. You're receiving a demand letter, you're receiving a demand for arbitration with typically JAMS or AAA, and it's from a California resident, and your business is being targeted, regardless of where in the country you're located or where you do business. You're just someone who operates a consumer-facing website. And the statute they're bringing these claims under is called the California Invasion of Privacy Act, or SIPA for short. And the screen in front of us kind of details what exactly SIPA says and what it prohibits, right? And it prohibits the interception of any, without the consent of all parties. California is what's called a dual party consent state for recording or intercepting communications. If you read or attempt to read or learn the contents or meaning of any message, report, or communication while the same is in transit or passing over any wire, line, or cable. And as Stacy had mentioned, there's case law that that expanded this idea of wire, line, or cable to internet communications, right? I mean, when this was passed by the California legislature, the focus was on eavesdropping on telephone lines, right? And if you've received one of these SIPA demand letters, you'll generally see, you're being accused of intercepting the claimant's electronic communications. And when you dig down in that and you ask about the details, it's generally just someone who visited your website and browsed the website. And the fact that they may have visited certain subpages or visited your website at all may be gathered by a metapixel tool or other tool you use for website analytics or for targeted advertising, right? And that's really the communication that they're alleging was intercepted, is simply the fact that this person visited and browsed your website. And as Stacy mentioned, the reason that plaintiffs' firms have really focused their claims on SIPA is because of this $5,000 per violation statutory penalty. And you see under 637(2)(a)(1), anyone who's been injured by a violation of this chapter may bring an action against the person who committed the violation for the greater of the following amounts: $5,000 per violation, or 3 times actual damages. And this is something that, the language in the statute that we're looking at here is something that hasn't really been decided by a higher court in California yet. And these have exploded over the last year or two. And there are some inconsistent decisions in the lower California state courts, in the district courts of the northern, southern, and central districts of California that haven't really been conclusive over exactly what constitutes a communication and what needs to be alleged to constitute damages. Because if you look at 637.2a, it clearly says any person who has been injured, right? And Roger, if you want to flip to the next slide, please. So there have been some recent favorable lower court decisions in California on these two issues, right? And the St. Augustine versus Great Wolf Resorts case out of the Southern District of California held that simply browsing and perusing a website isn't sufficient and tracking that browsing information isn't sufficient to allege that the contents of a communication were intercepted to form the basis of a SIPA claim. And that's it. For the majority of the claims we see, that's really all that's being alleged. And what we can get into it further, but generally what these claimants firms do is they'll obtain a client, and that client will provide the firm with their web browsing history. So whether you use Google Chrome or something else, you can track and print out your browsing history and provide it to the plaintiff's firm, and they target websites with demand letters and arbitration claims based on that. And based on this St. Augustine Great Wolf decision, like that visit alone isn't enough to constitute a violation of SIPA. They need to allege more, right? And if you're a website that collects personal financial information, credit card numbers, protected health information, you have a greater concern, because those are the things that have survived challenges, because that, as the courts have interpreted, that's what SIPA is really meant to protect. Despite this decision in July, like, we're still seeing these claims. This hasn't deterred most of these claimants firms. They're continuing to send demand letters, arbitration demands, for reasons we'll get into later about the costs of arbitration and the settlement leverage that it creates. But hopefully, if this issue gets to the Ninth Circuit, the California Supreme Court, we'll finally have a much stronger legal defense to this type of claim. And there's also a favorable decision in the California State Court as opposed on the statutory damages issue of SIPA, because, like we said, these claims, the vast majority of them, they're not alleging an actual injury, and you can't really allege an injury by saying you browsed a website and the fact that you visited was tracked or gathered. They're simply relying on the $5,000 statutory damage provision and nothing else. But in this Rodriguez Fountain 9 case from the California Superior Court from July, they found that there needs to be some allegation of a concrete injury in fact. So you have to allege that there was some injury. You can't just say, there may not have been any injury. We're simply relying on the $5,000 statutory damages part of SIPA. So these are two favorable case laws that we've raised in our defenses for different claims and arbitrations we've seen. And the hope is that these will be affirmed, or similar rulings will be issued by higher courts in the near future. And okay, so a lot of questions we see is, what types of businesses are these plaintiffs' firms targeting? They're generally targeting, focusing on smaller to mid-sized businesses, non-public companies, companies who who won't be subject to a lot of publicity because of these claims, and generally, they suspect won't invest heavily in defending against them. If you've ever received a demand letter or an arbitration claim, you'll generally see that in addition to saying that you violated SIPA or the Wiretap Act, they'll allege that you aided and abetted Meta or some other website advertising or analytics program in intercepting someone's electronic communications, meaning you have the Meta Pixel installed on your website. That's meant to track user visits for analytics, for targeted marketing. They're alleging that you aided and abetted Meta, but they're not actually bringing a claim against Meta, because they know that Meta has the resources to fight in court. Meta has the resources to lobby with the California legislature if necessary to address this. So generally we're seeing smaller businesses being targeted by these claims. And it's part of a business model on the claimants' firms to kind of extract quick settlements rather than to, litigate these through a full arbitration hearing or a trial. Will these claims change or continue over time? With case law developments and with different strategies companies use to defend these in arbitration, we certainly think that the claimants' firms will take a different approach. Lately, they've been focused on filing these in arbitration for a few reasons. Number one, it avoids the risk of having a bad decision come out from a federal or state court in California on the interpretation of SIPA. It allows them to keep kind of under wraps the volume of claims that they're filing. And generally, if the consumer arbitration rules apply, it forces companies to pay the fees. And in response to this, both JAMS and AAA have adopted mass arbitration rules to kind of aggregate claims when a company faces a large number of the same claims. So as more companies start to adapt, start to update their terms of service and incorporate mass arbitration rules as necessary, we think eventually that claimants' firm strategies will shift. You can move on to the next slide, Roger. And I'll pass it on to Stacy now, who's going to talk about some strategies for defending a SIPA or other privacy claim if you received a lawsuit or a demand letter or an arbitration claim.
Unmute myself. All right. Yeah, so as Mike said, we're seeing that a lot of these are filed in arbitration. And we think the reason for that is these firms want to keep these claims out of court for the exact reason that Mike was just alluding to. If there are more court decisions and more courts are seeing these things, there's the better chance that they will figure out what is happening here and potentially put a stop to these claims as they slowly erode some of the arguments that plaintiffs have to make under the SIPA statute. And the two cases that were cited, St. Augustine and apologies, I don't have the other one in front of me, but those two cases are examples as to why they want to stay in arbitration. Is a court has now ruled that you have to have an actual injury in fact, whereas when everything stays in arbitration, those are private and the volume of claims are private. So we believe that there's thousands of these, tens of thousands of these floating out there. But we can't look that up because in arbitration, there's not a public access to the docket or the filings that are filed in arbitration. Further, often arbitration requires a business to pay arbitration fees up front, and they can become significant, especially when there are multiple claims involved. And often if you get a letter demanding a payment of $100,000 and you're also paying $15,000 to $20,000 in arbitration fees up front, some businesses may just want to try and settle, and that is exactly what the plaintiffs or the claimants' attorneys are hoping for, is that you'll see these numbers, and rather than choose to fight it or hire an attorney to help you fight it, you'll just pay them a quick settlement, and often it's a lot less than what they're originally demanding. But these claims are not necessarily valid, and they're also assuming that you do not understand that, and which is why we're here today, to help try and educate some people so that you don't fall into the trap of paying the quick demand, especially on claims that have no merit. Roger, you can go to the next slide. What we've been doing is, and we've seen two different approaches, as Mike mentioned. We've seen firms sending out demand letters to businesses initially, and then if nobody responds to those, they then file an arbitration claim. And we've also seen the approach of the firm files the arbitration claim without a demand, and then sends that to the business and tells them to pay their fees we need to arbitrate this matter. With very bare bones information on the complaint, you often can't even tell what they're alleging the violation was, other than it falls under the SIPA statute. And so what we've when you receive a demand letter, what we've done is for clients is, in response, we raise our strongest defenses at the outset, letting them know that we understand about the case law in California, that there's no injury in fact, letting them know that you may have an arbitration provision that has a choice of law that is outside of California, and if that's the case, SIPA cannot apply to you. SIPA is a California statute. It will only apply to those who have California claims against them. And if you were able to apply, let's say, New York, Massachusetts, Virginia, any other state's law, the SIPA portion of it, which has the $5,000 penalty, can go away. And that is, as we said, what they're hooking a lot of their damages onto. And if they don't have that, they really don't have a claim anymore. And we've seen that when we file these letters, that often the claimants will just drop their claims because they rather go on to somebody else who doesn't know any better and take a quick settlement, and they're not really looking to litigate these claims. Unless there's actual injury in fact, oftentimes what will happen is the claimant will just drop the claim and will go away. And just so everybody knows, these claims have a 1-year statute of limitations, so you will have to wait for that year to be out for the claim to go away officially under the statute, but that's a pretty short period of time as far as statute of limitations go. The one thing I can advise is do not ignore a demand letter if you receive it. And the reason for that is California in 2019 passed a law that states that if a defendant is brought into arbitration and they refuse to pay the arbitration fees, they just ignore the arbitration, pretend they never received anything, the claimant can then bring a case in court to enforce the defendant to either go back to arbitration to pay the arbitration fees, or they can continue in court. But the problem with this is the statute allows for the court to assign the claimant's attorney's fees to the defendant for failure to respond to the arbitration. So if you ignore this, you could potentially be facing not only paying your own defense costs, but the claimant's defense costs as well, the claimant's costs as well. And so please don't ignore these things. Either reach out to one of us or somebody, respond to it, but ignoring it is not the way to handle this, especially if it's, like I said, under the SIPA statute. Next slide, please, Roger. And if a response is filed directly with AAA or JAMS, which are the two major arbitration arms that exist in the United States, what we are recommending is that we either file a letter with AAA informing them of the defenses that we have, and that this case has no damages, it's not ripe for arbitration and should not be arbitrated at all. And if the arbitration association disagrees, the next thing to do is to file a motion to dismiss, where we can raise choice of law or choice of venue issues, and also the strategies that we talked about previously, the lack of injury and so forth. And the goal is to try and get this knocked out as soon as possible. And we usually recommend doing that through a motion to dismiss as the initial response to be filed with AAA or JAMS. Next slide, please, Roger. And I kind of already touched on this, but why are plaintiffs firms doing this? They're looking for quick settlements and using the threat of arbitration fees to leverage people to pay quick settlements. You know, you get a letter in the mail saying you owe me $100,000. People panic, and oftentimes will call up and say, hey, but I'll accept 20, and that seems like a great deal. But again, these claims are often without merit, and so paying the 20 is still $20,000 that you shouldn't be paying. And then making an assumption that they also make an assumption that defendants will do exactly that, that they'll panic, call the plaintiff's firm and negotiate a quick settlement because they haven't done their research. They don't understand how these claims work, and they assume that the plaintiff's firm's letter is meritorious based on the way it's laid out. As we stated, that's usually not the case. And so they're banking on unsophisticated businesses paying these things, even for a nominal settlement value, rather than having to defend. Again, also, they may file multiple claims at once to try and ratchet up the arbitration fees that you're facing, which is why we recommend inserting mass arbitration provisions, which Mike will talk about shortly. And again, as Mike stated, they're targeting small businesses just for the unsophisticated person who doesn't know the law or doesn't have the resources to hire somebody, and in the hopes that they're just going to get a quick settlement. And what you can do to mitigate your risk here, we've kind of already touched on this, but if your business is not based in California, we highly recommend that you include a favorable state law in your choice of law provision in any terms of use on your website. And generally, any state besides California is going to be better, again, because California right now is the only state that has this $5,000 penalty that is automatically assigned, and they're using that again as a hook for their damages in attempts to scare people into quick settlements. Next slide, Roger.
Okay. So, one question we get from a lot of our clients who face, get arbitration demands, or they get letters demanding settlements, is what can I do to prevent this from happening, or what can I do to mitigate my risk in the event that I do receive a claim or a demand letter. And we've had clients who have faced upwards of 30 claims from the same firm, meaning 30 different claimants filing identical arbitration claims. And if you're in that situation, one effective way to address that is by incorporating AAA or JAM's mass arbitration terms into your terms of use. So what this means is, you'll have an existing arbitration provision providing that any dispute will be resolved by JAMS or AAA, and you add language that says, when applicable, the mass arbitration rules will apply. And what this does is, when you have a certain number, I think the number is 25, of similar claims filed in a related period of time, JAMS or AAA will appoint one arbitrator to oversee them. They'll kind of manage the discovery process and the administrative process of all the cases together. And generally, they'll pick one or they'll pick two to serve as what's called bellwether cases. And if it can't settle, you'll go to an arbitration hearing on those one or two cases, and kind of that will resolve a lot of the common issues between the cases. One of the points of leverage that the claimants firms use when they file upwards of 25 or more arbitration claims against a single company is these arbitration fees become substantial, right? You're getting deposits from 20 different arbitrators. You're getting filing fees for 20 different cases, and you're quickly looking, before you even get to an arbitration hearing on any of them, 6 figures in arbitration fees, and the claimants firms strategy as well, why don't you just pay that as a settlement instead of paying AAA or JAMS? And the mass arbitration terms is, we think, one of the most efficient ways to mitigate your risk and your financial exposure in that situation. And these were both just incorporated by JAMS and AAA in the last year and a half. So this is a new development, and obviously something that JAMS and AAA are seeing across the board, and they've reacted accordingly to try to incorporate rules that would make the administration of dozens and dozens of almost the same claim more efficient. Next slide, Roger. A few other things. So generally, when you're facing an allegation of whether it's SIPA, another state privacy statute, or the wiretap statute, is they're alleging that their communications were intercepted without consent, right? Because California is a two-party consent state. So if your call is being recorded, if your data is being tracked, they're using a broad and, we think, incorrect definition of communication, but it requires the consent of all parties, right? So cookie consent tools are an effective way to have a valid defense if you face these claims. So these are, and I'm sure you've all seen them when you visit a website, when you open the web page, before you can browse, before you can interact, it asks you to accept the cookie policy, right? And these are pop-up consent tools. They're often click wrap banners, right? When you'll open the website, there'll be a banner across the top or bottom saying accept, reject, view cookie policy. Those are good ways to, like I said, create a strong defense to these claims. They're generally not something that you can get dismissed at the outset, right? Like things that Stacy was talking about having a good choice of law provision or choice of venue provision. Those are ways you can get an arbitration claim or lawsuit dismissed like very quickly. These are defenses that might take some more time to prevail on, but at the end of the day, we'll obviously limit your liability and your exposure. And a consent pop-up or a click wrap banner that requires consent before you can access and browse the website is a lot stronger than a privacy policy that you have to click to a different page to visit and is kind of hidden, right? And that's what we see a lot of is, clients have a privacy policy, you have to browse, you have to find it, click it, but in the meantime, you could have already browsed and had data intercepted hypothetically. And that's what the claimants have alleged for people who don't have a click wrap or a pop-up cookie consent that requires you to accept the cookie policy before you can browse the website. Another strong point to make sure you have in your terms of use in your arbitration is a class action waiver. And that's for both lawsuits or class arbitration, right? So we've seen, obviously, these claimants firms typically don't want to file individual lawsuits. If they're going to file a single claim, it's likely to be an arbitration. The only time they'll pursue an action in court is if they have a basis to file a class action. And that's generally not a situation anyone wants to be in as a company. So it's important to have a class action waiver that applies to both lawsuits and also class arbitration that says you will not be a representative or member of any class, and any claims you bring have to be on an individual basis. Can you hop to the next slide, Roger? Okay, that's the end of our presentation. I did see one question, and I think we answered it on the cookie consent banner as an effective way to avoid claims. And I think the answer is yes, they won't always avoid claims, but if you have one, it's a good defense in the event you need to actually defend substantively.
Understood. Yeah. Thank you, Mike. Thank you, Stacy, for going through this. I know there was a few other questions here that I had as we wait for others to chime in with theirs. Do you envision changes to these state laws that will, in essence, close the loophole that we're seeing that allows these claims to be made and to move forward?
I think eventually, yes, particularly California will change their law on both like what constitutes a communication and what constitutes damage, right? But before that's going to happen, I think it's going to need some attention from number one, either the higher courts in California, because most of these decisions, the ones Stacy and I talked about today out of California, were state superior court, federal district courts. So it's going to require the attention of a higher court or some lobbying. And I think the claimants firms have been effective in avoiding that by targeting smaller businesses, trying to stay in arbitration, and until that they're forced to change that strategy. I don't know if the California legislature is going to like have the pressure or the attention necessary to make these changes.
So this is something that you see continue being an issue maybe here for the next 12, 18 months at the very least?
I think so. I don't think there'll be any major, unfortunately, any changes to the law in California, to SIPA or to any other statute that the claimants firms are relying on in the next couple of years. I just don't see it happening.
Understood. Okay. And Stacy, if
Oh, Roger, actually, there's a couple, sorry, I didn't mean to interrupt you. There's a couple
good.
questions in the chat that I wanted to get to.
Oh, yes, please, go for it.
Okay, so David Zimmerman wrote off topic, how is this different than the website accessibility claims against websites? Very similar. Those are ADA claims going after websites for not being ADA compliant. And the strategy is very similar here. It's under a different statute, but it's the same concept. Trying to drive quick settlements. Yeah, it's very similar. So that is well met, David. Good thought.
I can answer, James, your question about Massachusetts. Massachusetts, like California, is a two-party consent state, and they've seen some activity under the Massachusetts Wiretap Act, and as Stacy went over at the beginning of the presentation, there was recently a decision from the Massachusetts SJC that held that basically that browsing a website doesn't constitute a violation, isn't a communication interception. So that decision is very helpful for companies who might face a Massachusetts Wiretap Act claim. But to answer your question, it is a two-party consent state or all-party consent state. So there still is risk of seeing those types of claims.
Super. And then we got one more there from Cheryl.
So Cheryl, there are a lot of examples online that are available, but generally it's specific to your business, particularly the choice of law provision you might want to incorporate. One thing that I don't think I mentioned during the presentation is while you have an arbitration provision, have some sort of a pre-arbitration notice requirement, meaning like you have to alert us of this dispute X number of days before filing an arbitration claim. Because one thing we've seen is that we've had more success of getting the claimant's firm to drop a case when they've just sent a demand letter. Once they've actually filed that arbitration claim, it gets less likely, that we've seen them walk away from them before, that they're more likely to pursue it if they've already filed that claim. So putting something in there to say, you'll notify us in writing at X, at least 30 days before filing an arbitration claim, that can help protect you and alert you to a claim before you actually get hit with the actual filed arbitration claim. And generally, if AAA is administering the case and the claimants paid their fee, you're going to get something from AAA saying it's your turn to pay the fee. Because the way it works with consumer cases is, the business pays the majority of the fees for arbitration, but the claimant does have to pay an upfront fee. And once that's been paid, AAA is going to go to the business and say it's your turn to pay the fee. And once both fees are paid, a case administrator will be appointed. They'll send out paperwork to select an arbitrator, and they'll schedule an initial conference. So if the claimant doesn't pay the fee, you may not hear anything. But if AAA is sending you notices or JAMS is sending you notices saying the claimant's paid, it's your turn to pay, that's kind of when you get into the risk of being defaulted if you don't respond or you don't pay a fee.
Right. Okay. Well, that was two good questions there from Cheryl. Thank you so much for that. Just to wrap things up here, certainly though, we still have time to answer a few more questions. If you do have those, so continue to ask them in the Q&A feature. But lastly here, at least from my side, Michael and Stacy, if we have any California businesses online, right, and they currently have a California choice of law provision in their arbitration agreement, can they change it?
Mike, do you want to take that or you want me
I'll
to?
take it. I mean,
Okay.
you can change your choice of law provision, but it may not be of effect, right? Because what they're gonna argue to the arbitrator in that case is, this is a California consumer and a California business that's based in California or has a principal operations in California. SIPA should apply, right? And they shouldn't be able to use, without any good basis, another state's choice of law provision to kind of avoid liability under a state statute. So, it's possible, but it most likely won't be effective if the claimants decide to push it. If it's a California consumer and you're a California business, meaning, you're incorporated there, you have a principal place of business or some other nexus to California, choosing another random state just because they have favorable consumer protection laws isn't going to be effective in most cases.
Right. Understood. Okay. And then last question here. Why should businesses include an arbitration provision in their terms of use if, these are the types of websites being targeted?
So this is only one small portion of potential claims a business can face, right? I mean, and your potential liability outside of a SIPA claim really depends on the nature of your business. Are you selling consumer products? Are you a financial services business? Things like that, where there could be potential substantial liabilities outside of this SIPA issue. So we don't recommend that businesses remove an arbitration provision just to avoid SIPA claims, because that's something that you would have to discuss directly with an attorney about the nature of your business and what other liabilities you'd have. Because like I said, you don't want to generally it's good for a business to be in arbitration. This is a case where, under a limited statute, while they've exploded and a lot of companies have received them, this is a limited situation where a consumer prefers to be in arbitration.
Right. Understood. Okay. And, final thoughts, Michael and Stacy. Is there any final takeaways that you do want to share with the audience before we say goodbye?
Yeah, if you receive one of these letters, don't panic. Either reach out to Mike or myself, or if you have somebody else that you want to speak to about it. But we can help you navigate these issues. And there are ways to deal with this. There are multiple defenses out there. And a lawyer can help you navigate it. And we recommend you reach out to somebody to avoid having to pay money to come to these claimants over claims that have no merit.
Right. And Michael?
I second what Stacy had to say. These are obviously frustrating for businesses that receive them, but with with strong legal counsel, it's certainly something you can navigate. It's not going to be a business destroying lawsuit or claim, but just something you need to navigate. And Stacy and I have a lot of experience dealing with these claimants, particularly the lead claimant's firm, who's perpetrating the vast majority of these filings. And I think we've developed some good strategies to in a lot of circumstances get the claims to drop them, and in others to defend them effectively.
Excellent. Okay. And for those who did join us late, just a reminder for everyone, we will be providing a copy of the slide deck that was shown by Michael and Stacy here to all people via email. And within that same email, there will be a link to the video presentation of this. So those assets will live and they will be shared with you within the next 24 to 48 hours. Similarly, if you ever want to refer to them, if you can't find the email, they're going to be on the Darrow Everett website under the resources tab.